Before we even begin this courtroom hearing, let's set the stage for what you're about to witness. Today's case features a combination that judges dread and courtroom watchers love: a defendant who fires their attorney, decides to represent themselves, and then attempts to argue sovereign citizen-style legal theories in a probation violation hearing. Now that alone is already a dangerous strategy, but what makes this situation even more dramatic is that the defendant already had a deal negotiated by her attorney. In other words, the legal lifeboat was already in the water, and she just kicked it away. Probation violation hearings are not the place to experiment with legal theories or internet arguments. These hearings are usually very straightforward. The state presents evidence showing the probation conditions were violated, and the judge decides whether probation should continue or whether the defendant should serve the original sentence. That means the stakes are extremely high, because once probation is revoked, jail time is often immediate. And in this case, the prosecution has evidence including a failed drug test, missed reporting, and even new criminal charges. But instead of addressing that evidence head-on, the defendant has chosen a completely different approach, challenging the court's jurisdiction and claiming the state itself has no authority over her. So here's the big question for you watching right now: is this confidence, or is this a massive legal mistake? Stick around, because this courtroom exchange escalates quickly, and by the end, the judge is forced to make a decision that changes everything for the defendant. Alright, let's begin.
State versus Ashley Clark, 22 CR 216, Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this.
Let's pause right here because this moment is far more important than it might seem at first. When a defendant fires their attorney in the middle of a probation violation hearing, they're essentially stepping into a legal battlefield without armor. Attorneys don't just speak for their clients, they understand procedural rules, evidence standards, and how to challenge the state's claims effectively. Without that knowledge, defendants often walk directly into traps they don't even realize exist. The judge even warns her about this. Once she waives her right to counsel, she will be held to the exact same legal standards as a trained attorney. That means she must follow courtroom procedure, properly question witnesses, introduce evidence correctly, and build an actual legal argument. And here's the real problem: probation hearings operate under a preponderance of the evidence standard, meaning the state only needs to show it's more likely than not that a violation occurred. So if the prosecution presents a failed drug test, missed appointments, and new charges, and the defendant doesn't challenge those claims, the judge's decision becomes almost inevitable. But let's see how this unfolds as the prosecution begins presenting its evidence.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
No.
All right, state may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
Stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
Now here's where things start to fall apart for the defense. The prosecution has just introduced testimony from the probation officer that establishes several key violations: a positive drug test for methamphetamine, failure to report to probation, and new criminal charges. In a probation hearing, that kind of testimony is extremely powerful evidence because probation officers maintain detailed records and are considered credible witnesses in these proceedings. Normally, a defense attorney would cross-examine the officer, asking questions that might challenge the reliability of the test, clarify timelines, or introduce mitigating circumstances. But notice what's happening here: the defendant doesn't ask any meaningful questions at all. Instead of addressing the evidence directly, she pivots to a sovereign citizen argument about jurisdiction and whether the court has authority over her. The problem is that courts across the United States have consistently rejected these arguments for decades. Judges hear them all the time, and legally speaking, they don't carry weight in these proceedings. So while the prosecution has already built a clear case for probation violations, the defense hasn't presented any counter-evidence. That means the judge now has very little reason to doubt the state's claims, and that's going to matter a lot when the ruling comes down. Let's watch what happens next.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
And that's how this courtroom story comes to an end. The judge ultimately determined that the state had proven the probation violations by a preponderance of the evidence. The positive drug test, the failure to report to probation, and the new charges all stacked together to show a clear pattern of non-compliance. Because of that, the court revoked probation and ordered the defendant to serve the underlying sentence. From a legal perspective, this case highlights something incredibly important. Probation is often seen as a second chance, an opportunity to stay out of jail as long as certain conditions are followed. But when those conditions are violated repeatedly, the court has the authority to revoke probation and impose the original sentence. And without a proper legal defense, it becomes very difficult to challenge the state's evidence. It also shows the risks of representing yourself in court, especially when relying on arguments that the legal system simply doesn't recognize. Confidence alone isn't enough in a courtroom. Strategy, procedure, and knowledge of the law are what truly matter. Now I want to hear from you. Do you think firing her attorney was the biggest mistake in this case? Or was the outcome inevitable once those probation violations were proven? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.